I'm Craig Lee.
We'll start it again and then we'll edit.
All right. I'm Craig Lee,
I'm Robb McGee.
I'm Martin Burns.
and this is Real Talk with Robb and Craig.
We're really excited. We have a special guest today, Martin Burns, who is a real estate attorney. And he is going to be sharing some information with our viewers about when you need a real estate attorney and how it can benefit you. So Martin, without delaying too much, we'll throw to you right away. Tell folks, when should they contact you and when can you help?
Well, my suggestion is get the lawyer involved early. Have us review the contract before you sign it. We oftentimes get people come in and say, can you review the contract, and it's already signed.
Too late.
It does cause a problem at times. So get us involved early, because oftentimes I tell clients that the people who make me money are the ones who come in and say, here's what I've done, as opposed to the people who come in and say, here's what I'm thinking about doing. So I would suggest that when you enter into a purchase and sale agreement, if there's anything out of the ordinary, if you don't have a broker, if you're not using standard forms, if there's a lot of detail in a standard purchase and sale agreement, come into an attorney's office for about an hour, have them go over it, make sure it is what you expect. And a lot of times we find a lot of problems with purchase and sale agreements that have been drafted with and without brokers.
So you would recommend, oftentimes it sounds as though it would be worth contacting a real estate attorney and employing a real estate attorney, even if somebody's not having a problem, just to review a contract and make sure that they're protected.
Yeah, I mean, part of our job is to avoid problems, to avoid litigation. So, I mean, we can litigate as well, but it's a lot more expensive on that end of it than if you take care of it up front. And a lot of other things that people need to know is just, what does the contract say? You look at these contracts and they go on for pages and pages as if some lawyer just kept writing. And, people don't really realize what they've signed and what their obligations are under it.
Mm-hmm.
What is there, 27 or 36 pages in a purchase and sale contract?
Well, I mean, when you start adding the financing addendum, the inspection addendum, the well addendum, the septic addendums, and then you have the Form 17 issues, which is the seller's disclosure statements. Yeah, I mean, there's a pretty good stack of paper on a lot of purchase and sale agreements.
And this is no criticism of agents or clients, but a lot of times, they don't have a legally trained mind, so they're not looking for some of the pitfalls. And you explained to us before we started the show, there are certain things that would be very easy for somebody to ignore, miss, or just not be aware of that actually puts them in jeopardy if they don't have the right box checked or something to that effect.
Yeah, I mean, for instance, it's been the law in the state of Washington since at least 1931 that you need a legal description in a purchase and sale agreement. And we get purchase and sale agreements that come in all the time without a legal description. They'll put a parcel number in, they'll put an address in. Courts have been very clear that that's not enough. So if we get someone who comes in who wants to get out of a contract, we start looking there. If there's no legal description, the contract's void. So if you're trying to buy a house and you want to lock up the seller, probably want to have that in there. So that's just one thing we look at. Other things that come up a lot in purchase and sale agreements is people aren't exactly sure what to put in. They're not quite in agreement on something. Mm-hmm. And they put stuff in like to be agreed, to be determined, to be approved, those sorts of things.
Yeah.
And that is not a contract. An agreement to make an agreement is not a contract. And the courts have over and over said, we're not going to enforce it. You guys did not have a meeting of the minds as to this point. No contract. So that's one. There's one other big one that people get in trouble on the standard purchase and sale agreements. On the first page, there's a box down there about assessments, so like a utility assessment. Those could be spread out over many years, and you pay it along with your property taxes each year. But there's a box on the front that says that's going to be prepaid in full, or it's only going to be paid, the prorated portion up until the date of closing.
Yeah.
If that one says prepaid in full, I've seen people have to, take 15, 20 grand out of their sale proceeds to pay off an assessment early. So I'm always looking for that. It depends upon which side I'm on.
Yeah.
If I'm on the seller side, I don't want that box checked. If
Right.
I'm on the buyers, I want that box checked.
Yeah.
So, but that's just one of the things where people just don't know, and they don't really think about what that box could do to them.
Yeah.
And they don't know in their property taxes that there could be a sewer assessment or something along
Right.
those lines.
Right. Yeah. Oftentimes.
In 22 years, I didn't know it.
Yeah, that's fascinating, and obviously those are instances where even though you're not having an adversarial relationship with your seller or your builder or your realtor, these are things that an attorney could assist you with and potentially save you a lot of money either up front or down the line, depending on what the circumstance is. And then, unfortunately, we should take just a moment to talk about sometimes a buyer will find themselves in an unfortunate circumstance where a relationship has soured between the seller of a home or a realtor who's representing the seller or a builder, and you can find yourself in a situation where you are having to fight in court to protect the purchase of your new home.
Oh, yeah, we do that as well. And when people come in to me to see that, the first thing I look for is, do you have an enforceable contract? Because the worst thing I can do is get someone into litigation that they don't have a reasonably good chance of winning. You know, if there's times in all litigation where there's risk, and so you make the client aware of the risk. But if they want to go sue someone for specific performance and where there's no legal or there's a bunch of to be determines,
Right.
I can't do it. So I tell them that. But if they have a legally binding contract, then usually the first thing we do is we kind of send out the nasty letter and say, you know, dear whoever, you're about to be sued, and here's what we're going to do, and lay it out to them and encourage them to go seek legal counsel, who hopefully would look at my analysis and say, well, he seems about right. You know, you're gonna get sued.
Yeah.
You know, you might want to actually honor your contract, and then if they don't, then we can file the lawsuit. We can put a lis pendens in at the auditor's office, which is a notice to anyone who's buying the property that they take subject to the results of that litigation, which generally puts an end to that. Yeah, I mean, that clouds title. And there's risk in doing that because you can get hit with damages if you wrongfully cloud someone's title. But then we can move forward with a specific performance action and request a court order the person to comply with the terms of the sale. And then we seek damages, of course, in every purchase and sale agreement. All the standard form ones has an attorney fee clause. And we seek to get the attorney's fees back, which generally, if you force the seller to sell, it's just going to come right off the purchase price. So, yeah.
This is great information, and obviously this is just scratching the surface. If you have legal questions or need of an attorney, we highly recommend you contact Martin Burns. Our office has used him personally. He's an outstanding attorney.
Highly recommended by Mike Runyon. I'm
Yeah,
happy
that's
to say
right.
that.
That's right.
Who
Yeah.
is a great realtor and owns Remax here in Tacoma.
Martin, how would folks contact you if they had questions or wanted to retain your services?
Well, when I get done blushing here, you can call me at in Tacoma 253-507-5586.
Fantastic.
Also, don't forget to go to www.realtalk.mortgage. That takes you straight to our YouTube channel. That'll be posted today at 1 o'clock.
Yeah, and this is part one of our discussion with Martin. Next week, we're going to have him back as a guest again, and he is going to discuss for you some of the basic overview of a 1031 exchange. So be sure to tune in for that.
I'm Craig Lee.
I'm Rob McGee.
Martin Burns.
This is Real Talk with Robb and Craig.